Telephone Foundation, and I'd like to welcome you to the webinar that will inform participants of the Kansas Government Control and Local Food Policy Law. This is House Bill 2595 that was passed this last legislative session that would, among other things, preempt local governments from establishing laws that would impact food retail and food services. Today you'll hear from Kathy Demeron, lobbyist for the Kansas City Healthy Kids, who will discuss the political background of House Bill 2595, followed by Julie Ralston Aoki. She even has it. Anyway, she's a staff attorney for the Public Health Law Center. She'll provide an overview of House Bill 2595 and explain what it does, what it doesn't do, and where its impact is yet to be determined. Then Misty Lechner with the American Heart Association will be discussing what steps local food and farm councils and health coalitions can take if they are worried about House Bill 2595 and how it may slow or stop their progress. Finally, Natalie Fullerton, the Program Director at the Kansas Rural Center, will facilitate the questions and answers from the participants. With that, I'll turn the webinar over to Kathy with KC Healthy Kids.
Good morning, and thanks for that introduction, Jeff. I appreciate everybody stopping and taking time this morning to join with our colleagues throughout the state and becoming a little more aware of some of the ramifications of legislation that was enacted this past legislative session in the form of House Bill 2595. I'm going to be talking to you in the context of how it was that this bill came into the soup kettle of legislation that was being considered this past year, how we managed to become more aware of the ramifications of it, which is a process that's still unfolding and will continue to unfold, and then a little bit about the individuals who were strong proponents of the legislation, along with those of us, many of whom are on the webinar today, who raised questions and concerns about it. So to begin, I think it's important to understand the backdrop of the Kansas legislative session of 2016, and it was one actually that started several years previous in terms of our state elected officials becoming somewhat more intrusive in the operations and functions of local units of government. Many people look at the 2016 legislative session and consider it to be a pivotal one as it relates to state policymakers becoming very embroiled in local issues. Some of the key battleground policy arenas in which that thought out took place in terms of education funding and policy, and ways in which, even though the same group of Kansas citizens vote for their local school board members, as vote for state legislators, as vote for governor, not as though we have a new electorate that comes in and only participates in one versus the other. These are the same Kansas citizens, but state lawmakers felt that they needed to insert themselves in education policy that otherwise would have been just under the jurisdiction of local school districts. We saw that also play out in terms of the way in which local units of government, cities, counties, school districts, recreation commissions in some cases, dealt with gun control and the concealed carry law. Another major area of policy where state lawmakers inserted themselves in the management and operations of local government came in the form of even further restricting a tax lid. In other words, the ways in which local units of government can raise resources, tax funds, to operate vital services like infrastructure, roads, bridges, being able to fund their police departments and other units of law enforcement. It went so far as to even have the state legislature determining the way in which local elections are conducted, so as to decide that, for instance, rather than have our municipal leaders elected in the spring, as has been the custom for tens of years, we now have moved local elections to coincide with those for statewide candidates and members of the state legislature in the fall. So it wasn't terribly surprising to see lawmakers not stop there, but go a step further and insert themselves in the policy arena of nutritional labeling and the policy and the other items that are contained by way of jurisdictional restrictions in House Bill 2595. And I know that Julie will speak much more in detail, and we would love to answer your questions about the content of 2595, but I thought this quote really summarized the way in which everyone, both proponents and opponents, saw it, and that was that it would restrict municipalities' ability to require food establishments to post nutritional information, including caloric content and allergen warnings. It was a bill that, of course, did much more than that, as it's explained in this quote from the head lobbyist for the Kansas Association of Counties, Melissa Wangeman. Their perspective was the same as ours, which is 2595 would restrict local regulation and decision-making in many ways on public health issues related to nutrition. It's another state encroachment on local control. And there are many legislators who were concerned about the further encroachment on local control, but not to the degree that it was successful in stopping the bill. So here's a brief timeline for how quickly things happen in the state legislature. You will remember that lawmakers gather always the second week of January. They spend the following 90 plus or minus days in Topeka working on legislation. We have a bicameral system where bills have to pass both houses, traditionally anyway, and then differences between the two versions are worked out. It goes to the governor for further action. But here's how 2595 found its way into becoming public law in our state. Again, this session had been about 30 days into its duration when sort of the majority of new ideas and bills hit the radar screen is usually around early February, and that's what happened in 2595. It was introduced as a committee bill, which means through that process, no one individual or group of individual legislators had their name on the bill as sponsors. It was sponsored by or it was introduced anyway at the request of Representative Gene Sulentrop from Wichita, who is an active member of the Kansas Restaurant and Hospitality Association. So he asked his colleagues on the House Appropriations Committee to please have the bill introduced. It then quickly became subject to a hearing in the House Commerce Committee where, for those people who were in attendance at the first hearing, I think you would readily agree that confusion reigned supreme in that process. There were an inordinate number of questions about the actual language of the bill, what the intent of the bill is, and what the implications would be if the bill were to become law without further review and amendment. So the committee chair allowed a week for members of the advocacy community and members of the committee to work outside of the committee process and try to come up with clarifying amendments. There was a general sense at that point that the bill, while it was described as being a measure to, quote unquote, prevent Kansas from having Bloomberg-type restrictions on large quantity soft drinks and have restrictions on non-GMO labeling restrictions, there were so many other pieces included in the language of the bill in terms of zoning and restrictions on health disparity regions that no one could specifically speak to as a subject matter expert, that there was a great deal of angst on the committee. Nonetheless, there was enough energy behind the bill. The advocates for the bill had convinced legislators that those two main points would reign supreme and the rest of this would sort itself out and they needed to pass it. So the committee passed it. They did make some amendments to try to narrow the scope, to add some clarifying language, and it passed out of the committee in mid-February. It was then sort of lingering on the House calendar, which is the debate calendar, for a month, which allowed for more dialogue between the advocacy community and members of the legislature to try to gain a deeper understanding of it. Many of us were more interested in suggesting that the bill not advance at all, so that there could be further reflection and more study done rather than have something that led to more questions than answers. But the bill did pass the House, again, with further amendments and clarifications by a pretty strong margin. It was 89 to 34. And in a little bit, we'll talk about some of the reasons as to why it had so much support. But again, keep in mind that we have a pretty conservative state legislature, along with a great interest in the farm community. So when you talk about non-GMOs, that brings to the debate a little different flavor than just folks who are interested in restricting nutrition. This bill didn't ever go through the Kansas Senate. So they short-circuited the process, and instead of having a full set of hearings, discussion, debate, roll call on the bill as introduced in the House once it got over to the Senate, that stuff never happened. What happened instead is in late April, when legislators came back for the veto or wrap-up session, the language as it had passed the House of 2595 was folded into a conference committee report. So that means it was put in with other subjects that were germane to it, in terms of restricting local units of government in this case. And there were further amendments made in that conference committee process. It was adopted then by the Senate by another overwhelming margin and was sent to the governor with an effective date of July 1st. So how did this bill find its way into the Kansas legislature? We all were sort of asking. It came from a couple of different sources working together at the national level. And those two sources were the American Legislative Exchange Committee, or ALEC, which is an organization of conservative-minded individuals who believe in smaller government and sort of replete with restrictions, and many of the things that we have seen of late in the Kansas legislative process have been model ALEC bills. They were working in this case in partnership with the National Restaurant and Hospitality Association to do just as they purported, which is to try to keep states from adopting laws that would allow for restrictions on serving of nutritional items and on down the list. But they developed a pretty broad coalition because of the farm interest in our state. So they brought in the list of individuals you see on the screen before you: Americans for Prosperity, the Kansas Beverage Association, the Chamber of Commerce, the State Chamber of Commerce, that is, the co-ops, the corn growers, the Department of Agriculture supported this, Farm Bureau, the Livestock Association, Restaurant and Hospitality Association, wheat growers, and then Representative Gene Sulentrop. And I would point that out as a way to illustrate that when you are working in the state capitol and you have a bill that you're interested in seeing become law, it's very, very helpful to have a legislative champion on your side, someone on the inside who can talk to his or her colleagues in the way that members of the advocacy community do not. And Gene Sulentrop played that role. But members of the advocacy community who are interested in health and nutrition, certainly many people on our call this morning, really stepped up to the plate and were terrific advocates and grassroots opponents of 2595. I won't go through the entire list because you can see them in front of you, but it was a broad array of folks. We had members of the agriculture community on our side as well. We had individuals from the health foundations, local units of government, health advocacy organizations, the YMCAs, and folks who otherwise would be seen as very credible individuals and voices on behalf of public policy that will gain traction for health and nutrition in our state. I'm pleased that we were able to get the bill amended in ways that did add clarification, that clearly stated that individuals such as yourself can do nutritional information programming, that we can continue to look at policies and have a very vibrant community at the local level in terms of looking at nutrition and healthy eating and active living. We were at the last sort of juncture of this successful in having the bill amended so as to make sure, for instance, that the Double Up program for farmers markets was not restricted by it. But there's still a lot of questions about the bill. So at this point, I'm going to turn it over to Julie, who will walk us through the content of the bill. So thank you, Julie.
Thank you, Kathy. This is Julie Ralston-Aoki with the Public Health Law Center, and I'm going to start by just giving a very brief introduction as to the Public Health Law Center. I think many of you might know us, have worked with some of our staff in the past, but I thought that would be helpful. We are a nonprofit legal technical assistance center located at the Mitchell-Hamlin School of Law in St. Paul, Minnesota. Our mission is to help people use the power of law to improve health. We work with public health officials, researchers, advocates, and communities at the local, state, federal, and tribal levels to support development of public health laws and policies that are grounded both in good science and good law, and that are tailored to be workable and right for the specific community. So with support from the Kansas Health Foundation and through many of the partners that are on this webinar today and some other Kansas groups, we've had really the privilege and good fortune to work with many of you and other communities in Kansas to support healthy eating, active living, and tobacco control policy development. So this picture here, I like to try to humanize our center as a picture of our staff, and circled in orange are my colleagues Natasha Frost and Mary Narrow, who many of you might have worked with on other occasions, and then I'm there in the bottom row. In terms of what we do, we serve the public health field by offering 5 basic types of supports, which are listed here. And one of the key ones, of course, is legal research. We do a lot of legal research to help advocates and public health officials and community members to understand the legal landscape that they're in and to help inform them their policy development efforts, as well as to inform the trainings and the publications that we do. We also provide litigation support through strategic consulting to the government attorneys who might be defending public health laws, and also through friend of the court briefs, so where we can bring in a public health perspective so that the court can understand the public health ramifications of a new law or of a pending challenge. Even though we are a legal center, we're not traditional attorneys in the sense that we don't represent clients and we don't lobby. And in a nutshell, what we do is we see the main point behind our work, and the work of public health advocates like yourself is to help kids like Alex and Mio here to have healthy choices easily available to them and also to want to choose them. So launching into kind of the meat of my section of the presentation this morning, what this law is really about is this idea of preemption. It's a legal concept, and again, you might have heard about it before, but I thought it wouldn't hurt to just kind of cover the basics here. So this law, HB 2595, and the Senate version is 366, is a preemptive law, which is a preemption is a legal doctrine where the idea is that a higher level of government, like the federal government, can preempt a lower level of government, like the state government, or the federal and state can preempt local laws. And what preemption means is sometimes it can be a complete taking away of authority to deal with a specific issue. Sometimes it can be just a limitation. And a lot of the challenges with preemption, of course, is trying to figure out exactly what the scope of it is, how much of it covers. And this is the same kind of challenge that we're dealing with this law today. Now, the reason why preemption really matters is because it's been a favorite tool to really try to limit or undermine many public health efforts. So, this certainly is not a unique kind of challenge or issue. in the food policy world or any public health world. So in this quote, I think is a good illustration of why, as we know that so much effective public health policy comes from the local level, which are our laboratories of democracy, and our local communities are places where policymakers tend to feel more directly connected to the communities they represent and more accountable for the public health challenges that their communities face. And so it's for this reason that the tobacco industry, for example, has been a well-documented and sort of infamous player in the use of preemption to thwart public health efforts. If any of you worked in the area of tobacco control policy, you may have heard about this admission from a tobacco lobbyist who, when he was dying from a smoking-related cancer, had a change of heart and decided to reveal many of the industry's strategies for fighting public health measures. And one of the things that he talked about was that one of the industry's key strategies is to try to preempt local control, to concentrate power at the federal level where the tobacco industry was able to exert a lot more influence, and if not at the federal level, then at the state level, again, for the same reasons. So I'd like to kind of revisit this history for people and to help, place this issue in the larger context of public health work. And then I have this map here to show you, where Kansas sits sort of with the rest of the nation. This is what we're seeing is that the food industry has taken a page from the tobacco industry playbook and is using the same strategy. So the states here with the red dots represent states where preemptive laws have been passed, many of them modeled after some of the language coming out of ALEC, the American Legislative Exchange Council that Kathy mentioned. So as these are 12 states since 2008 have passed these kinds of laws that restrict how localities can regulate restaurants or other types of food retailers in order to address concerns about food with poor or no nutritional quality and the related public health concerns. This isn't a coincidence. ALEC, the American Legislative Exchange Council, it sounds like a bipartisan, neutral, and objective organization, but in reality, it's an organization that is funded by food companies and other very powerful industries with members from mostly one party, and it's a mechanism to allow industry representatives to actually design and vote on model state legislation that is then meant to be taken back home by state legislator members and introduced then within their states. And, no big surprise, but this legislation, the model language, is usually designed to prioritize corporate interests and goals over other types of concerns. So most of the states you see on this map with the dots, they have passed variations of some type of ALEC model language. But some states only preempt menu or calorie labeling. Other states only preempt the setting of nutrition standards for meals that are marketed to children. But in Ohio, Mississippi, and now Kansas, the much broader language from ALEC has been passed. I just want to say a note about the Ohio, and you see there that it's crossed out, and this is because the city of Cleveland actually challenged the law in Ohio and managed to obtain court decisions that really call into question the validity of this law. Cleveland had just passed a restriction on the use of artificial trans fats by restaurants and was poised to initiate several other policy changes to support healthy eating and other things actually across the community right before the law was passed in Ohio, again at the request of the State Restaurant Association. So the city challenged the law and alleged that this preemptive law violated the state's constitutional home rule provision. The city won the challenge both at the trial court level and the appellate court of appeals level. So this law, which is very similar, almost identical actually to the Kansas law, is on shaky ground in Ohio. Unfortunately, after losing both at the trial court and the court of appeals level, the state did not take the appeal to the state Supreme Court, the highest court, so there isn't a final statewide ruling on this decision, but again, it's on pretty shaky ground. So it seems possible that the Kansas law, which again is identical in many key areas to this Ohio law, could be on some uncertain ground as well, given that Kansas also has a strong preference for home rule, also contained in its constitution. So there are some good reasons to wonder about the constitutional validity of this law. Also, as Kathy kind of alluded to, and I'm going to go into more detail, there are portions of this law that that come from the ALEC model language that are not very well drafted. Some of the language is really broad. There's a lack of sort of good, clear definitions. So that can make it kind of hard to understand how to apply and interpret the law. And broad, vague language means that there's a lot of gray areas, which also means that it can create sort of some confusion as well as reasons to challenge it. But assuming that the law is constitutionally and legally valid, I'm going to go into more detail here about what it clearly seems to do and what it clearly doesn't do. And keep in mind, for some of these things, it's going to be hard to know for sure what the final answer is, what the law covers or doesn't cover, until or unless there's some kind of a challenge and a court has to interpret it for us. And I wanted to highlight for you, we've created a resource with the help of many of my fellow presenters and other partners that is available on our website at the link shown there, which covers a lot of the same information that I'm going to convey to you today and in more detail in some cases. So I don't want you to feel like you have to take frantic notes. You can go look up this resource. Now, the gist of, or the essence of this government control law is that it prohibits what's called political subdivisions from passing laws that would regulate a wide range of food retail environments and food service operations, and I'm going to unpack that a little bit. But what the essence is that it's trying to limit the power of local governments to try to improve retail food environments and promote healthier food systems within their communities. In terms of who is actually restricted by the law, some questions have come up about that, so we wanted to address that for sure. So the law says that political subdivisions are restricted, and how the law defines that as political or taxing subdivisions of the state that receive, expend, and are supported in whole or in part by public funds. So it's government entities that can make laws and also collect taxes. So this is like cities, counties, school boards, townships, those kinds of entities. It does not cover private groups or voluntary civic groups, for example, foundations, community groups. This law does not restrict what private voluntary groups can do. In terms of what kinds of food environments are covered, this is a little bit more complicated, but what the law says is that it preempts local authority over what it refers to as retail food establishments and food service operations, which are defined very broadly to include any place in which food is served or is prepared on the premises for retail sale or service for free while hot or heated by the seller, is mixed or combined by the seller for sale as a single item or sold with eating utensils, and is intended for immediate consumption. So, essentially ready-to-eat, prepared food that you could eat right away. So the law does have a lot of specific examples, which it covers several of which are listed here, and then it has a catch-all, which is also listed on the slide, which, as you can see, is a very broad definition. And so even though, for example, grocery stores aren't included in the definition, explicitly listed in the definition in the law, it seems to cover like grocery stores that might sell hot, ready-to-eat foods, as many grocery stores do now. Now I'm going to go into the policy, the specific types of policy options that are covered. We've talked about what kinds of actors, are limited. We've talked about what kinds of food environments. Now I'm going to talk about the policy. So the law says that local jurisdictions and even other state agencies can't enact or enforce laws or ordinances or link a licensing or other regulatory approval process to the availability of food nutrition information. The law says that only the Kansas legislature can do this. So as Kathy talked about, this means that local governments can't adopt their own menu labeling or calorie labeling laws for restaurants or vending machines, even though that would be allowed under the new federal menu labeling law that's going into place. The law also says that local governments can't pass laws related to food that comes with a consumer incentive item, and hopefully you can hear the quotes in my voice there, or link a licensing or other regulatory approval process for a restaurant or retail food establishment with whether or not these kinds of consumer incentive items are given away with food. And so what that means, essentially, is like some jurisdictions outside of Kansas have passed laws that say restaurant meals marketed to kids because they come with a free toy or crayons or some kind of item like that have to meet minimal nutrition standards, or they have to come with a default beverage like water or milk and not pop. So it's these kinds of local laws that are not a possibility in Kansas if this law is valid. It also could apply to places where adult meals come with some kind of incentive item like a coupon or some kind of a club, membership like many restaurants offer for adults. So the preemption law also takes away local authority to restrict the sale, distribution, or serving of food or drinks that have been approved by another government agency. And what's interesting is that it doesn't even say that it has to be a Kansas state agency, but it seems like it could be an agency from another state too. I think that this may have been meant to prevent something like the cup size limit rule on pop that was tried in New York City. Again, Kathy mentioned that, those kind of Bloomberg sorts of laws. But, ironically, it's not really clear whether the law would actually work to do that. It would depend on how a court interpreted this particular language. The law also tries to take away authority, local authority to pass laws that restrict the growing or raising of fruit, vegetables, or other crops or livestock that have been approved for sale by any government agency. Again, so this could mean, like as Kathy mentioned, something like a restriction on GMO types of crops, but again, it's a little bit unclear. One of the most troubling parts of the law is that it tries to limit what local governments can do to address food-based health disparities. The government control law says that local governments can't restrict retail food establishments or use their licensing, permitting, or other regulatory approval processes based on the existence or non-existence of a food-based health disparity. And it doesn't define what those words mean, but refers instead to just saying as defined by the CDC or the Institutes of Health, or again, a government agency. But as all of us who work in public health know, health disparities, where people from socially disadvantaged groups experience poor health outcomes compared to those who are from socially favored groups, simply because of their race or their age or where they live or their socioeconomic status, those kinds of factors, we know that this is a real and widespread problem, not just in Kansas, but actually, across the United States and even across the world. We also know that many health disparities are linked to lack of good access to healthy, affordable food. You probably have seen a version of this graphic before, but as it illustrates, dealing with health disparities requires taking an equity approach that focuses on those who are most disadvantaged and allocating resources appropriately to get support to where it is most needed and is going to be most effective. So we also know that food-based health disparities are closely linked to geography, like whether you live in an urban or rural area, how close you live to a grocery store, whether you live in a predominantly African-American or predominantly white neighborhood or a predominantly low-income neighborhood. So the Kansas preemption law limits the ability of cities and counties in Kansas to come up with geographically tailored approaches to addressing these kinds of food-based health disparities when it comes to a wide variety of food retailers and food retailing practices. So I'm going to try to switch gears here and get a little more positive and talk about what is still clearly doable under this law. Due to the efforts of many of you and my fellow presenters, language was added to the law to try to remove some of the confusion and make clear that there were some things that weren't going to be affected by the law. So here's a couple of examples to start with. The preemption law says that it was not meant to limit local government's general planning and zoning authority. So, for example, questions about community gardens have come up, or community kitchens, or those kinds of activities. Well, to the extent that those kinds of activities are governed by the community's general zoning and planning laws, there shouldn't be any kind of problem, and those laws can still be applied to them and still, allow those kinds of activities to continue. Nutrition education activities are also expressly allowed under this new government control law as long as they are not part of a law that restricts another entity. Similarly, programs, nutrition, financial assistance programs to promote healthy eating, such as the Double Up Bucks program, which allows people to get double their value for some of their supplemental nutrition assistance program benefits or SNAP benefits when they buy fresh produce at a farmer's market. These are just fine. Again, they're expressly okay under the law unless they are part of a law that restricts another entity. Questions have also come up about food and farm councils. These aren't, or food policy councils. These are not specifically mentioned in the law, but again, these kinds of bodies should be just fine. They can still exist. They can still be created. They don't typically pass laws. They're not they don't tax others, so they don't fall within the definition of a political subdivision. Of course, now the recommendations that they might make as to what should be done might be more limited because the options are limited, but still those bodies can still exist. And then the law also expressly states that it is not meant to interfere with cities and counties and other political subdivisions that own or run their own food service operations, and they can still set minimum nutrition standards for these to try to get healthier foods and drinks into those operations, again, as long as they are not done through a law or ordinance that restricts someone else. Okay. Well, I wanted to spend a minute here to talk about unintended consequences. So, as you've been probably picking up, the law is not very well written in some respects, and some of it is really broad and vague, so it shouldn't be surprising that there is likely to be some unintended consequences. Some obvious potential ones include that although the law protects zoning authority, oh, that's my timer to tell me that I'm done. Just shut that off. Okay. I'm going to wrap up here very quickly. So although the law protects zoning authority, many jurisdictions, communities in Kansas may regulate animal husbandry like chickens or beekeeping through licensing or other ordinances, not through zoning. So this preemption law would call into question some of the continued validity of some of these laws. And it doesn't seem like lawmakers intended to reach those laws, but that might be what happened here. The law also says that local governments can't restrict the sale, distribution, or serving of foods that have been approved for sale by a government agency. Well, if there's a local law that sets a preference for local foods in a government cafeteria or institutional feeding program, would this be a restriction on serving other types of legal foods? I'd like to think not, but again, it's a little unclear. Similarly, could a community use its licensing or permitting or regulatory approval process to bring in a grocery store to an underserved area? It's not clear how the law would impact this kind of activity since it does prohibit localities from using their regulatory process, again, based on the existence or non-existence of food-based health disparities. It seems unlikely that legislators intended to impact some of these things, but again, with the way the law is written, there are some real gray areas. So I just want to thank you for your attention and for your listening, and I'm looking forward to any questions you might have. And this is my contact information. If you want to send me any questions offline or talk more about it, I'd be glad to talk with you. Again, here's the resource that we developed with the partners here and where you can find it. And now I'm going to turn things over to Misty Lechner of the American Heart Association and Kansas Alliance for Wellness. She's going to talk about next steps for food policy councils and food and farm task forces.
Thank you, Julie. I will still leave some time for questions at the end of this webinar, so still feel free to type those questions into that Q&A box since there will be a few minutes. I wanted to start off by thanking our presenters that already gave a thorough overview. I'm going to speak for just a little bit on how this will actually impact the work of food and farm councils, food policy councils, and our local health coalitions. I am the Advocacy Project Director for the American Heart Association. I also manage the Kansas Alliance for Wellness, and some of you may have actually tracked updates on this bill and this law through our newsletter and other emails that I sent out. So for those of you, thank you. And I'm going to start off by just showing this map and saying that the red counties, those are the current food and farm councils in Kansas, and the green are emerging councils. And all of these councils are safe. Yes, they've been established by formal government action, but these are safe under this law. So we are okay None of you have been unestablished. The only thing it will do is it will probably change the way you approach things as you work towards healthy and local food policies. I also want to thank all of you who are on this call and others that couldn't join us today for your hard work. Many of you responded to the calls to action earlier this year when House Bill 2595 was introduced. It was a difficult battle, as evidenced by the photo on this slide of an actual tweet from one of our lawmakers. It was difficult, but I can say without any doubt in my mind that you all did make the difference. It was because of the action you guys took and others that couldn't attend today that the lawmakers paused. And even though many of them still actually voted in support of the bill, they listened to you and they did pass good amendments. So thank you all, and I actually really look forward to seeing what's to come in the future with healthy food and local food policy on the local and state level, despite this little setback with 2595. So how can councils and health coalitions actually move forward with healthy local food policy priorities? Well, I have put together 5 steps to help kind of guide your work. And the first 2 steps is know what the law covers and know what it doesn't cover. So you've taken the first step today by attending this webinar, but also review the Public Health Law Center resource that Julie talked about. See what's in there. It's got kind of that this is what we know and this is what we don't know. But step 3 is prepare yourself for that gray area. Not everything is black and white. Julie alluded to this. And not everything in this will be black and white until it's decided on by the courts. And it can't go to the courts until someone decides to contest it, like Cleveland did in Ohio. So there is some gray area, and that is unfortunate. But it doesn't mean we can't still make progress and we can't still move forward. So how do we do that, even with this gray area? Well, if you are told no, or even if you're told I don't know, by your board of directors, your city, your county, your legal counsel, your funders, anyone who influences your decisions to move forward on a policy campaign, please tell me. Because if we can start identifying these common themes across the state and these common challenges we're all experiencing, well, then we're well poised to collectively address it. The more people that are impacted, the greater our ability is to influence change. So please tell me, and I can start logging this so we can work together. And then step 5, some of you might experience the lawyers for your city or your county feeling very uncomfortable with approving a policy. But that doesn't mean you should stop. In fact, Julie Ralston-Aoki with the Public Health Law Center has graciously offered to speak to them, lawyer to lawyer, to talk about everything she has learned while researching this law and actually with all of her other preemption work as well. So then to summarize, step 1 and 2 is know what the law covers and doesn't cover. Step 3, be prepared for that gray area which can make you uncomfortable. Step 4, if you're told no or I don't know, contact me. And step 5, if you need to, have your legal counsel talk directly to Public Health Law Center and Julie. And finally, I know that there is a lot of work that we have yet to do. We can't possibly know all of our questions today. We have a lot of adventures in creating healthy local food policies ahead of us. So as you come up with those questions, as you come up with those concerns, please reach out to me. I am here. I don't have all the answers, but what I can do is start directing you to other people who might have the answers. So here's my email address and my phone number. Write it down. And when you start experiencing challenges or you have questions or you just want some assistance, you contact me. And now I will turn this over to Natalie to help facilitate our question and answer portion of the webinar.
All right, thanks, Misty. So for those of you that may have gotten on the call later, there is a little Q&A box down in the right-hand corner. And so feel free to type out any questions you might have in that box, and we will try to get them answered. So we have about 10 minutes left in this call for questions, so please feel free to get your burning questions out there. We do have one question here, and this I think I'll go ahead and throw out to all of our panelists to see who would like to answer it, or one or all of you. So the question is, could the incentive portion possibly be applied to double up food bucks, since that program is a nutrition incentive program, providing an incentive for the purchase of food at farmers markets with SNAP dollars?
Well, this is Julie. I can take a stab at that one, and I think I kind of touched on it too in talking about what the law covers. But you know, that's a great question, because it is a little confusing, because those double up bucks certainly do seem to match that definition of a consumer incentive item, but then there's also language expressly included in the law that says, you know, this is not meant to prevent governments or political subdivisions from participating financially in a food assistance program as long as it's not trying to do it through a law that restricts someone else. So, you know, I think taking those portions together and interpreting the law, I'd say you'd be on pretty safe ground that those types of programs are not should not be impacted by this law, and that those should be okay. And particularly since they're used to purchase fresh fruits and vegetables, because the consumer incentive item piece is really tied to a meal being served or acquired from a food service operation. So hopefully I think that there's enough sort of guidance there in the law that those programs should be okay.
Julie, this is Kathy. The only thing I would add to that is, if it should become an issue of contention at whatever jurisdiction, there is substantial documentation as it relates to the committee report that spoke to this very issue and legislative intent, which is that it should not in any way be interpreted to be restrictive.
Okay, great. Thank you for those answers. I think we'll go ahead and move on. We have a few more questions coming in. So the next question is, if school clubs run concession stands at school events, can they pass policy on offering healthy options at concession stands, or are they restricted? Well, tackle this question.
This is Julie again. I will again try to take the first run at it. And then again, there is express language that was included, an amendment to the original model language that says that this law should not restrict a political subdivision, which would include school districts, from owning or managing a food service facility or serving food products, you know, as long as they're complying with the Kansas Food Code, with the food safety laws, which everybody knows they have to do anyway, and their own policies, as long as those policies are not laws or ordinance that restrict someone else. So a school board or school district or school passing a policy, that is not usually going to be considered a law or ordinance that's going to, a law or ordinance. It's an administrative policy. So again, those types of things should be on pretty safe ground, but this is a great example of just how, you know, this law is just very confusing. And again, Kathy may be able to chime in some on the legislative history piece of this, or others, please, I invite you.
Julie, this is Kathy. I think you've done a great job of explaining the intent. That was an amendment that was added expressly to make sure that local units of government could do as they saw fit as it relates to the food operations that they were running themselves, but that that sort of approach wouldn't apply to food organizations or restaurants in their jurisdiction that they weren't operating themselves. So there is a distinguishing language between the two.
Okay, great. Thanks, Julie and Kathy. The next question that we have is, which part of the law is most susceptible to a challenge, and what should advocates be doing now to prepare?
So this is Julie again, and this is really a complicated question, and I think not one that would really be easy to answer, particularly through a venue like this. So let me just tell you a little bit about the Ohio litigation, maybe, and how Cleveland approached it. So Cleveland challenged, there's a home rule amendment to the Ohio state constitution, and there is one as well in the Kansas constitution, which grants localities a lot of power to regulate themselves or to pass their own kinds of laws. And then there's also a one subject amendment to the Constitution, which again many state constitutions have. I don't know for sure if Kansas does, but I wouldn't be at all surprised if it does, which says that when you're enacting laws, the bills have to sort of be address one topic. And the way the Ohio law was passed was it was slipped into literally page 1,351 or something like that in the middle of like a 3,000 page budget bill, omnibus bill. So it was really buried. And so the city of Cleveland challenged it on two grounds, that the law violated the Home Rule Amendment and also violated the one subject amendment. And they won on both arguments all throughout the litigation. And so there were, certainly we helped to write a friend of the court brief to support the city, to bring in the public health perspective there and to explain to the court the tremendous health disparities that existed in the city of Cleveland, which led them to create this Healthy Cleveland initiative, which was where the trans fat restriction came from and where there were other plans to do some other things around healthy eating, active living, and tobacco control. And so, we brought in that perspective and explained, what are health disparities and what are food-based health disparities and how those were particularly pertinent to Cleveland. It was clear that the court did listen to those arguments, but there were also these other sort of technical legal arguments that were very persuasive to the court. So, that was the basis for the Cleveland challenge, and whether all of those same kinds of arguments would apply in Kansas, I couldn't say sitting here right now, but it seems like there could be some possibilities.
Great. Kathy or Misty, do you have any other additional thoughts? The next question is, are there any organized efforts underway in Kansas to challenge this law? And I think, Julie, you may have started to address that question, but if any of the panelists have any other thoughts to those two questions, that would be great.
This is Misty, and I would say that right now there are not organized efforts that are well underway to challenge the law, but I think there are a lot of people that are thinking about it and wanting to really talk through how we might strategically approach this. So I would highly encourage anyone who is on this webinar that if you are considering such action, to let us know. We might be able to pull in some other resources and some other partners that could assist if that is an approach that you would like to take.
And I'll just add that, and with our work, typically what we see when public health laws are going through a legal challenge, it's much more typical where it's a situation where a city has passed a law or a county has passed a law, And then an affected business owner, say a restaurant or a bar or, or a trade association that represents several of those types of businesses will sue to challenge the law. It's not very often like what happened in Cleveland, where the city itself decided to sort of preemptively challenge the preemption law. And so that's just something to keep in mind when you're thinking about this issue, that that the Cleveland experience is a little bit unique, but it was certainly, from a public health perspective, really wonderful to see a city have that kind of courage and the capacity. That's really important too, to have the kind of capacity to bring those kinds of arguments and try to make that case.
All right, great. Thank you, Julie and Misty. We are approaching our 1 hour time limit for this webinar, but we did have one more question that was submitted prior to this call that I think panelists might be able to answer easily, and that's how will this impact the policies created from the 1422 grant?
Well, I was going to say, I think it really depends on what the specific policies are. So it's kind of hard to answer that generically.
This is Misty, and I'd be happy to help facilitate a dialogue between Public Health Law Center and the Kansas Department of Health and Environment's Bureau of Health Promotion, and see exactly how it will impact those priorities. But as Julie said, it's hard to know without having that list of policy priorities in front of us. I would be happy to help facilitate that dialogue and maybe come out with some specific talking points on what it does and doesn't impact.
Great. So if you are on this call and a recipient of the 1422 grant and have this same question, please feel free to get a hold of Misty and Julie. Okay, so I think our time is about up. I think it's safe to say that if you are thinking about what was presented today and come up with questions today or later on, feel free to contact the panelists on the call today. They provided their contact information in the slides, and I do believe this presentation has been recorded. So it should be available to listen to and to view again. All right, so with that being said, are there any additional thoughts or closing comments the panelists would like to make before we end the call today?
Oh, just want to thank everyone. Thank my co-presenters and thank everybody who listened this morning.
Great. Well, thank you, everybody, for attending the call today. And like I said, if you have any follow-up questions, feel free to be in touch with us, and we will be sure to get your questions answered or get you in touch with the people that can answer your questions. All right. Thank you very much, and have a great day.